here is the thing. A lot of people think that once you set up a living trust, life is great. After you die, there will be no problem. And there will be no sibling rivalry. There will be no creditor. Your assets are all in trust. My husband and I went to visit his siblings at Thanksgiving, and his older brother, who is really smart businessman, he proudly says, "Oh, I don't own anything. Everything is in my trust." So we all laughed. Obviously, he doesn't know probate code section 18200. If it is a self-settling trust, it is not the kind of a corporate veil that keeps your assets alienated from the creditors, but that's what a lot of people think. And a lot of people also think that if you have a trust, your children will not fight. Everything will be administered according to the trustor's wishes. And as you know, that's not the case. So terms referring to the decedent's asset. So this obviously here, we are segregating probate estate, which is different from other assets outside of a decedent's probate estate. And obviously, this is not the same definition IRS uses when you file a 706 tax return. What is in the 706 is different from what is available in probate estate for the creditors and what is not available. So let's look at the left column. Decedent's probate estate are the assets in decedent's name alone and properties held with the others as tenants in common. Let's look at the right column. What is not in the decedent's probate estate? The first one, assets held in decedent's revocable trust. That does not mean that this asset is not available to the creditor. Let's just put that on the shelf for now. In terms of a probate administration, the probate petition that you file and you have to go through the probate court, these assets in trust are at least outside of the probate. And this is the number one reason. A lot of people these days don't have 11 million or 22 million. They don't even have to worry about estate taxes. But number one reason why people create living trust is because they don't want their children to go through the probate procedures. And not only it costs money, but your entire finances become public knowledge. So people want to avoid the probate. So your living trust asset is outside of the probate estate. Next one, properties held with the others in joint tenancy. This is the worst thing that can happen to creditors. This is the cheapest asset protection that any debtor can do. And a lot of lawyers surprisingly don't know that. But I also noticed that a lot of laypersons know this device. It's really amazing when some people are interested in avoiding creditors, they really pick up this knowledge. And I've seen so many quitclaim deeds, and these are not only drafted by non-lawyers, these are drafted by people whose native language is not even English, but they know how to create a quitclaim deed and change a title from, John Smith to John Smith and Jane Taylor, not tenants in common, as joint tenants. I also have seen quite a few older people using this joint tenancy asset protection device when they want to escape medical and Medicare lien. And joint tenancy is like the strongest device. So as soon as one joint tenant dies, the property, simply as you know, because you do trust administration, it goes to the other joint tenant. Next one is a community property. And actually, speaking of joint tenants, like a lot of older people who are using joint tenancy as Medi-Cal and Medicare avoidance techniques, when they find out that they don't get the step-up basis and there are some income tax issues when you have held the property in joint tenancy, they're like, oh, I didn't know that. Can we change that? I'm like, no, you use the joint tenancy as an asset protection device. So once A dies, the joint tenant B gets it, but they don't get the step-up basis. So you have to pick and choose. Next one is community property with the right of survivorship. This is a different animal than joint tenancy. A lot of people in California, especially husband and wife, hold the property in this format so that they can get the $250,000 each capital gains exemption and also to get the step-up basis. And then when one spouse dies, they get the tax benefit and also the other person automatically becomes the only title owner. But I will talk about pros and cons of holding your house in this way, whether the surviving spouse can avoid the creditors when you hold the assets in this format. I have a real life example on that. Next one is pay on death accounts, usually bank accounts. The final one is retirement accounts, IRAs, 401ks, life insurance, all these creatures federally regulated, ERISA-controlled devices. It doesn't matter what your relationship is with the decedent. The only thing that controls is the beneficiary designation. One time, it was a very sad story. There was a guy in his 70s, and out of the blue, he started dating a girl who was like 18, and they got married. And the 18-year-old lady became his wife number 3. This old man divorced his wife number 2 many years ago, but forgot to change the beneficiary in his life insurance policy. Wife number 3 was a drug addict, unemployed. She needs money. She was technically the widow, but when he died, she had to learn that the insurance company doesn't care. Whoever is the beneficiary gets the money. So California community law does not apply when you deal with the financial products governed by ERISA law.